Hi, everyone. We are back for part 3 of our Veterans Information Series. This week is on discharge upgrades. Of course, now I can't get, there we go. So just a little bit about me first. I am a 16-year attorney. I'm licensed in Florida and in California, U.S. District Court of Middle District of Florida and the U.S. Court of Appeals for Veterans Claims. My father was a civilian engineer with the Navy, and my husband is an Army veteran. My first career was in nursing homes doing admissions and marketing, but then I decided to go into law and to be an advocate for others. And for originally it was for the people who were in the nursing homes. And but as my years have continued, I have expanded out. And now I am working with Community Legal Services in Florida. I started here in 2016 after working in the private sector. And with Community Legal Services, I started on the Helpline and moved in to the Public Benefits Unit as a staff attorney, working primarily in Social Security benefits and veterans benefits. And now I am the manager of the Public Benefits Unit, which does house the veterans benefits, as well as other public benefit matters like Social Security, Medicaid, Medicare, reemployment assistance, and supplemental nutrition program, otherwise known as food stamps. I do sit on the Orlando City Mayor's Veterans Advisory Council, and I want to give them a big shout out and thank you so that we can have this information series. It wouldn't be happening if it weren't for them. And I do work closely with veterans who are a part of supportive services for veterans and families, the SSVF program, housing program, and work to help them or help provide holistic services to them, not just veterans benefits, but any area that we can help them. And that is for veterans who are homeless or at risk of homelessness. And finally, I'm the chairperson for the Central Florida Reentry Network's Veterans Subcommittee. So before getting into the meat of discharge upgrades, it's important to know what types of military discharges there are. There is the honorable discharge, and with an honorable discharge, a person can get VA healthcare, disability benefits, the GI Bill, just about every benefit available they would be eligible for, including that GI Bill. Which is different than once you start going down. It starts getting less and less. So the next one is the general, or otherwise known as an under honorable conditions. Veterans discharged with that characterization, they will get the VA healthcare and the disability benefits, but not the GI Bill. An uncharacterized discharge is somebody who generally wasn't in the service for long enough to be able to characterize them as either having a good discharge or a bad discharge. It's kind of neutral. They may be eligible for benefits depending on how long they were in. But it's still too short of a time just to be able to give them an honorable or other than honorable, general, whatever the case may be. And then an other than honorable, not quite a dishonorable, but other than honorable, veteran wouldn't get benefits, but they can request a discharge upgrade or character of service determination and appeal to get the benefits that they need. Somebody who had a bad conduct discharge or dishonorable discharge, they do not get benefits at all, and they do not have the option of the character of service determination, but they can apply for a discharge upgrade. So it's really a muddled kind of thing, as you can see. So the first thing that would start is you need a character of service determination. This is really for the other than honorable situation. A veteran would need to have a character of service determination um, before starting anything, depending on what it is they're looking to get to. But character of service determination is triggered by applying for a benefit, and then the rest would be triggered on the denial of the benefit. But as you can see by this flow chart, I'm not going to go through all of it in detail, but it it does base what is the characterization on the DD 214, and then going from there, what is, looking more at what the reasoning it was. So obviously somebody with an honorable or general under honorable conditions would have a good character of service and would be able to get benefits. But when you get into dishonorable or dismissal, bad conduct other than honorable, they're looking at what the reasoning is, because there are reasons that could prohibit benefits at all. If it was an AWOL, if it was, or absence without leave, or unauthorized absence, if the person was considered a deserter, if it was a discharge for the good of the service, in lieu of a court martial, those may be prohibiting any kind of benefit. So for the character of service review, I'm going to talk about timing a little bit later, but it is thought that it may be able to get a quicker review to at least be done by filing for VA home loan eligibility certificate. And that can be done by the form or by applying on e-benefits, because you would need to have that service characterization or determination for the loan eligibility. And then also for someone with an other than honorable discharge, they should still be eligible for health care, even if they, with a bad characterization, and with an other than honorable. But they would only get the health care for conditions that the VA determines to be related to military service. Another exclusion for people who are having trouble getting health care, victims of military sexual trauma, they have to receive the healthcare treatment regardless of the type of discharge characterization. And the way that this would come about would be the veteran would have to make a claim for service connection for healthcare benefits. So I know this feels kind of back and forth, but I think this overview of the process as a whole will help sort things out. So you make a claim for compensation or pension or the VA home loan. They're going to make a character of service determination. And if that determination is unfavorable due to an other than honorable discharge, then the veteran can apply for service connection for VA healthcare. They can appeal the character determination to the regional office, and they can apply for a discharge upgrade with their military branch. If it is a determination that's unfavorable due to a dishonorable discharge, then the person can apply for a discharge upgrade with their military branch. Now, here's another thought. It may be that you can get the service connection for VA healthcare just by going to the enrollment department at the local VA clinic or healthcare center and submitting a form for enrollment, even if you haven't filed that claim for benefits, that's going to make that determination. But most clinics will require the character of service decision first, but never hurts to try. All right, so claim for service connection for VA healthcare, the way that works is first starting at the enrollment specialist at the VA clinic. It is a 10-7131 form, and that goes to the regional office. This is so you're making an internal request for this to go to the regional office. So that there can be a service connection adjudication for whatever your health condition is. And then you want to get a copy of that. Make sure all the I's are dotted and T's are crossed so that they have checked off adjudicative action, service connection, and that the name of the health condition is in the remarks. And then go on to e-benefits. So if you're not near the regional office for Orlando City would be St. Petersburg. So probably right now, especially, you don't want to head that way. So e-benefits is the best service or way to do it, but you can submit a claim for service connection for healthcare benefits only through there and attach your copies with whatever documentation you have to support the information on there. And then just follow up, make sure the claim was actually created. E-benefits will show that. But this claim does take longer than others, so be prepared for that as well. And I mean, just like any other process, it's going to be a long process. You're not going to get the healthcare right away. So now I mentioned before, if you're denied benefits, you can appeal to the VA regional office for character of service appeal on the character of service denial. You have 1 year to do that. Other than that, you can submit a discharge upgrade application that goes to the Discharge Review Board or the Board of Corrections for military records. And you can file both the appeal and the discharge upgrade application at the same time. And some things to make sure and think about, more than one enlistment may be eligible for VA healthcare and compensation based on an honorable term of service. So look if it's more than one enlistment and what the character was on another enlistment, then that may help. Also submit evidence of honorable service like awards, length of service, mitigating factors help as well, such as PTSD and military sexual trauma. And these will help to help with your eligibility on the character of service appeal and hopefully a change in decision. And timing is everything, as I mentioned before. So you've got your character of service review and discharge upgrade. Both of those take over a year for a decision. So that's why when I said before, you can do them at the same time, it's probably a good idea because they're both going to take a long time. And then you don't want to have to wait for one to finish before the next one. If the character of service review is determined first, then benefits will start immediately upon the favorable determination, and you can get your benefits while waiting for the discharge upgrade determination. And if once the discharge upgrade determination is made, assuming it's favorable, it is binding on the VA regional office. So if there was a different decision on the character of service. They have to go by whatever the discharge upgrade was. So if it was unfavorable character of service review and a favorable discharge upgrade, then you would still get the benefits based on the discharge upgrade, and you would be eligible for benefits upon that favorable decision. All right, so now we've got more more people involved here. So applying for a discharge upgrade, there are two places where it can be made. The first one is a discharge review board. The discharge review board application cannot be made any more than 15 years from the date of discharge. There are no exceptions to this. So you want to make sure to apply within that 15-year time. Otherwise, I'll go into the next options for that, but you're risking not having anyone review it after the 15 years. But try for the 15 years. And I'm going to back up here because I realize I did not put this in here. A lot of times I hear when people come to me that they didn't do it within the 15 years, but they were told when they were discharged that it would automatically upgrade after 1 year or maybe after 5 years. This does not happen. And I hear it a lot, but there are no automatic upgrades. You would have to do this. So it's always best to do your application for discharge upgrade. I generally feel like within 5 years of discharge is probably the best time. You complete the DD form 293 and it goes to whichever branch of service. You do want to request your military records first so that you know what they're reviewing, and that way you can pull specific pieces that to refer to in your application to show them why your discharge character should be upgraded. You do need to show that it was improper or inequitable the way you were discharged, and it's your burden to prove this. So you need to make sure that you're getting everything you can from military records and evidence after your discharge to show that you've been an upstanding citizen since. And that may include if you have PTSD or total brain injury, MST, anything that might require mental health records, you want to get those. Get references if you are still in contact with anyone from the military, get references from them, get references from volunteer groups or churches or religious organizations, character references for people to talk about how you are. If you have been able to maintain employment, then employment references help. Job history helps, in which Social Security might be able to help with that, to show what kind of money you've been putting into the system to show that you've held a job. You may want to do a background check on yourself and submit that with it to show that there haven't been any problems since your discharge. Those are just some examples of things that can go with it. But it should be more, no matter what, it should be more than just the DD form 293, because they need you to prove that this was improper and inequitable and it shouldn't have happened. And just submitting the form alone is not sufficient. So another tip, you want to ask for a records review when you're filling out the DD 293. Ask for the record review only and have them make a decision based on the records and whatever you submit with your application. Then later you can do it again and ask for a personal hearing, but it is in Washington, D.C., and you have to pay your own travel costs. So that's usually why people can't do it. So you first of all don't want to do it the first time around if you can't make it, to a hearing, but also you don't want to ask it for it at all if you're not going to be able to make it to Washington and potentially have witnesses with you as well, but definitely have your evidence if you're going to go to the hearing. But this is another reason to do it this way is you are getting 2 bites at the apple. You can ask for your records review first, then ask for personal hearing if you're denied during the records review. You can't go the other way around. It has to be records review first and then hearing request. And then these are the branch review boards. So each one does have their own. There's the Army has their own address where you would send the 293, Form 293 to, Navy and Marines, then the Air Force and Coast Guard. Now, if you miss that 15-year deadline for the Discharge Review Board, or if you're denied at the Discharge Review Board, you can apply to the Board of Corrections for military records. And again, each branch has its own Board of Corrections. There is, if it was a denial, then there is a 3-year deadline to apply to the Board of Corrections from the date of the Discharge Review Board denial, or a discovery from the injustice. So if you didn't realize until 30 years later that you were suffering from PTSD and that was causing your problems in the military, and that's why you had this other than honorable discharge, or even dishonorable discharge, bad conduct discharge, whatever the case may be, then you, at the time, if you're diagnosed 30 years later, then you've got another 3 years from that. And the standard to have the Board of Corrections to hear it, they have to decide that they will hear it within that time period after the 15 years, but they can make a motion. You want to make a motion to have the time limit waived in the interest of justice. Right. And the Board of Corrections of military records do have a broader authority to change records, but it's always better to go that route and have your shot with the Discharge Review Board and then go to the Board of Corrections within the 3 years from the denial. All right. Now, what is different with Board of Corrections is that there is no personal hearing option. So you have to put everything on paper. This form is a DD 149. I have it listed later too, 149. But you want to put the same type of evidence, everything together with the form. Don't just fill out the form, but put your evidence with it, identify parts of the military record that helps with it. And again, be sure to request those records and submit them with the application showing the favorable records. And the thing is too, if you don't request your military records and you submit without anything, it is going to be very difficult to get those records once they have a discharge upgrade application in hand. And this is true for both the Board of Corrections and Discharge Review Board, because they are going to have the records. And so when you request them after the fact, no one's going to be able to get access to them. So you want to get it beforehand. Then you know exactly too what is going to be in front of them. And again, if you are granted a discharge upgrade, a new DD 214 will be issued, and the VA, including the Health Administration and Benefits Administration, must use your new upgraded discharge status to determine eligibility for benefits. And then they have each branch again, you mail your DD 149 to each branch. All right, representative accreditation. Anyone, if you want somebody to help you with the process, it's always wise. Is somebody who can help you with getting records or at least advising on what you need and whether a character of service determination would be successful or not. Somebody who would know the prohibited actions that cause the discharge. But you do want to make sure that person is accredited by the VA to help you with that. And it could be a veteran service officer or veteran service organization, a VSO, an attorney, or a claims agent. All right, some community service resources for you. E-benefits is always a great way to have access to your claims file and history. Veteran Service Office in Orlando, we have one on Michigan Street. 211 will always connect to local resources. And then there's the Orlando Vet Center as well. They provide counseling for combat veterans and families. And they, although part of the VA, they will provide services with a dishonorable or other than honorable discharge. So they can at least provide that counseling and while you're seeking an upgrade if that's something that's possible. I'm moving through pretty quickly here. Do we have any questions before I go on my next couple slides?
None in the chat. Anybody have?
I have a question.
Sure.
So if both the DRB and not the records review and the hearing. So if they're both denied, then you have to do the BCMR.
Correct.
And if that's denied, then you just.
Then that's about as far as you can go.
Okay.
Yeah, there's no appeal right on the BCMR.
Okay. Thank you.
You're welcome. Any other questions?
None in the chat.
No? Okay. All right. Well, we are also a community resource. We are a full service civil legal aid law firm. We promote equal access to justice. Our primary clientele are low income people, and we're trying to protect livelihoods, health, and families. And we provide services to more than 20,000 people in Central Florida, and nearly 1 million qualify for our services. So that's only a small portion, I think, comparatively. And anyone who is interested in our services for veterans benefits or any of our other areas of law that we cover, we do have a helpline, which is staffed by attorneys, and they can help in most areas of law. They can make sure that you're qualified for our services and then provide you advice on the issue. Veterans benefits would go directly, they would do the intake and make sure you're qualified for services, and then they would come directly to my public benefits unit our public benefits unit that I manage, and probably talk to me about about your needs, and we can go from there. So we've got 2 more of our 5 sessions in the Veterans Information Series. So the next 2 Fridays at noon, you can go to clsmf.org/calendar to register. Next week, we'll be talking about veterans dependent and survivor benefits. And then the week after that will be access to healthcare inside and outside of the VA. And do